Welcome to the People's Law School. Ladies and gentlemen, here we are again after about 25 years of being here in Huntsville, Alabama, one of the smartest places in the universe, and your presence here is a representation of that. But we bring to you the best lawyers around. We are the Alabama Association for Justice, the Alabama Trial Lawyers Association, and we bring to you, as I said, best lawyers in America, best lawyers around. Joshua Patrick Hayes is our first speaker tonight, and he is from Tuscaloosa. He works for a firm known as Prince, Glover, and Hayes, started by my friend Bobby Prince, and Bobby Prince is a part-time professor at the university, and what he's done is Bobby Prince is a real smart guy because he's one of my friends, but what he's done is he's picked out the absolute best students that have gone through Tuscaloosa, the school there in Tuscaloosa. And Josh Hayes is as you will note by the other things I tell you about him, is one of those. Josh, by the way, is one of the selected one of the best 10 personal injury lawyers in Alabama, which is incredible because he's only 40 years old. But he's always been in the pursuit of excellence. He got his degree, cum laude, in accounting from the University of Alabama. When he was a senior, he was selected the most outstanding senior of the University of Alabama. He thereafter was a cabinet member for the governor of Alabama, and he was one of the youngest people to ever serve in the governor's cabinet. He works for several nonprofits, and he and his wife donate much time to various service organizations there in Tuscaloosa. They have 2 children, by the way, Stella Grace and Caroline. But tonight, our friend Josh Hayes is going to talk to us about industrial accidents, which is a topic he knows a whole lot about. Josh.
Thank you, Alan.
So much.
Thank you. Thank you for having me.
Thank you. Thank you.
Well, good evening. Always glad to be with my good friends at the People's Law School, especially excited to be here tonight to talk about a subject that is a passion of mine. You know, industry in Alabama obviously is important, and over the last couple of decades it's changed a lot. Now we have all the automotive suppliers, Hyundai, Honda, Toyota suppliers in North Alabama, of course Mercedes and Tuscaloosa. And you know, when times change as far as industry, so do the kind of injuries that occur. And that's a little bit what I want to talk to you about today. You know, obviously industry is a good thing, but when you're injured on an industrial site, it's usually a very significant and serious injury because you're not talking about 2 passenger cars that collide. Instead, you're talking about either a fall from a serious height, big earth-moving pieces of equipment that malfunction and hurt or kill somebody. And so these are significant and serious cases that my firm is fortunate enough to handle. I read today that in 2014, which is the latest statistics that are out, that there were 4,679 workers killed on the job in the United States. It wasn't broken up by state, but that averages 13 workers a day in America are killed on an industrial site. And so some of the things I want to talk to you about are maybe some ways that workers can improve their own safety, but also some ways that employers and owners of industry can do a little better job at protecting the people that are working for them and ultimately delivering goods and services to us. So this first case I want to talk to you about is one that I handled in Tuscaloosa a couple of years ago. A worker was hired to clean the gutters on this industrial building, and it was his very first time at the job site, his very first time on this particular building. He was hired by a subcontractor, and when he gets to the building, all they tell him is, here's your bucket, here's the ladder, go clean out the gutters. Okay, that's it. They didn't check his prior employment, they didn't give him a drug screen, they didn't make sure he had the proper safety harnesses and equipment that we're going to talk about in a few minutes. All they did is said, go get the job done, get out of our way, we need our gutters cleaned. And you know, unfortunately that happens all too often when business owners are just in such a hurry to get the job done that safety really is not the priority. And so as you can see from this slide, this young man who was 19 at the time fell over 30 feet and landed directly on concrete. Now, probably because he was 19 and bulletproof a little bit, he did live. had life-altering injuries, including bilateral hip fractures. Those are some of the worst, as you know, severe pelvic fractures that required a lot of surgery. He was a member of the armed services at the time and had dreams of deploying and going to represent our country in Iraq and Afghanistan. Of course, he was not able to do that. He had a lifetime injury that was caused because of these skylight panels. Now, he was not warned at all that there were even any skylight panels on the building. You could not tell from looking at the roof from the side where he climbed up that there were panels at all. I'll show you in a little bit that there are supposed to be warnings on buildings, and there are supposed to be screens around skylights. If you can't put a screen around it, you're supposed to put a screen under it. You're supposed to make sure that that the workers have the proper safety harnesses and whatnot, because falls are a common thing in industry. In fact, the construction industry talks about the fatal four a lot, and falls are the number one thing. The number one causes of death in the industry is a fall. So business owners should know this. There's all kind of literature out there. This particular business not only did not warn of any skylights, but they thought the skylights should last forever. All right? So the picture to the right there is the new skylight panel. After he fell through it, they replaced it with one that was less than 30 days old when we took this photograph. The one on the left is what the rest of the building had at the time, and unfortunately, I'm here to tell you that's still what that building has. It's right around the corner from my office in Tuscaloosa, and it still has skylights that look like that. They're made of fiberglass. They weather. They age, you know, rain, sleet, hail is all part of it, and not to mention sun. You know, sun is a big, it takes its toll on skylights and the fiberglass over time. So, what does our government say about skylights in general? OSHA, as you know, is an important governmental agency, and I want to, before we even get to what this slide says, I want to talk a little bit about OSHA. Occupational Safety and Health Administration. It's a part of the Department of Labor. It's a small agency. Would you believe that over our entire country that there are only 2,200 OSHA inspectors? All right, now compare that to over 130 million workers in heavy industry, and you see there's not much. In fact, that ratio is 1 inspector for every 59,000 workers. So it's one of those situations that there's just not enough inspections, not enough training that goes on to these workers. We now have over 8 million work sites in the country, and so if you take 2,200 inspectors and 8 million work sites, there is no possible way that over the course of a year that each of them is even going to be seen one time, much less on a follow-up inspection basis. But back to this standard, which is kind of the general industry standard for OSHA as it relates to skylights. Every skylight floor, opening, and hole shall be guarded by a standard skylight screen or standard railing on all exposed sides. Now, this case that we're talking about today was my first skylight case, and since that time I've handled 4 or 5 others. I have never one time deposed a business owner who had ever heard of this standard. Right? Nobody knows about it. Now, is that because the government is not doing a good job putting it out? Is that because the insurance companies that insure these buildings aren't doing a good job of training their business owners? Or is it because the business owners get these bulletins from OSHA and just file them away in the garbage can? Maybe some of all of that. I don't know, but I'm just telling you, this standard, which is the law in Alabama and in the United States, is not known about by the workers. Another case I worked on involving a skylight happened in Clark County. Unfortunately, this man who was injured on this roof was paralyzed. He was 52 at the time, general laborer, had never worked with anything but his hands, no education, no chance of him earning a living now because he's permanently paralyzed, because he was hired to get on this roof, to cross to another roof, to fix a piece of siding that had been damaged in a tornado. And so this particular industry hired him and told him to go up there And this photograph is pretty interesting to me because, and we're going to look at it a couple of different times today as I tell you a few more facts. Again, the skylight that you can see there, the only real one in the photograph that you can see, is where he fell through. That's a replacement skylight. Would you believe that there are 4 other skylights in that photograph there that you just can't, or if you can see them, your eyes are better than I can. And this is the view coming from the ladder that my client had when venturing out onto the roof. I had the owner in his deposition to put an X over another skylight, and he did, and it's over there to the left. I've circled it with a red pen, but they're hard to see. They're especially hard to see if the lighting is just not right. You know, if it's sunny and in your eyes, or if it's cloudy for that matter, if the roof is the same color as the skylights. And so, industry recommends, the government recommends, and our safety experts recommend that instead of skylights like this, you ought to have skylights like this. A little easier to see, isn't it? All right, now these are not guarded either, but at least the worker can see what the dangers around him. These are not approved by OSHA either, but again, they're safer than something that you just can't see. Now, in both of the cases we've talked about so far, the worker who was injured testified that he was not warned of any skylights, he was not provided any safety equipment, he was not, until he fell through the skylight, he didn't even know there were any up there. And so in these cases, it's not uncommon to blame the worker, and that's what happened in both of these cases. But if they don't know the skylight's there and had never been in the building before, I don't know how they're supposed to know about it. Now, there's another OSHA standard that comes into place that talks about something called a PFAS. That's a personal fall arrest system. It says each employee, while working on surfaces, shall be protected from falling through holes, including skylights, if the holes are more than 6 feet above the lower levels. And we're going to talk in detail about these PFASs. They're also supposed to be covered and guarded even if they have these kind of safety devices. The gentleman in the photograph there, you can see, is wearing a harness. He's tied on to a part of the building that's called an anchorage point. There are safe ways to be on buildings. Now, you're not going to completely take away the risk, of course, of falling. He could still fall and hit his head, but he's not going to fall 30 feet to the ground if all of his safety equipment is working properly. With regard to the personal fall arrest systems, it's the complete package here. You can't just have part of it. You got to have all of it, and it's got to be tested regularly. It's got to be OSHA approved, but it would include the belt around his waist there. It would include the anchorage point that connects to the building. The connectors are a lot of times D-rings, and industrial-sized D-rings are something called a rope grab. That's a standard part of these cases. Deceleration devices is something that if the worker is falling, the technology is there that if they go, say, more than 10 feet in so many seconds of a fall, that they'll automatically catch. And again, they're injured that way too, but they're not injured as badly as if they fall 30 feet to the ground. Now, I do want to talk, I've investigated a couple of cases in the past year where the lanyard itself malfunctioned. And so again, these things are not foolproof. You can't leave them in the back of a work truck. You can't throw them under a house. They've got to be regularly inspected. And OSHA will help train workers if you ask them to. There are industry courses that business owners can go to if they are proactive enough to want to protect their workers. Most of them that I have found so far are not. And so the law puts a responsibility. This is kind of like in a trucking case where the DOT standards apply to everybody. They apply to the driver, they apply to the company owner, they apply to the dispatchers, they apply to the people who investigated their background. Well, in this case, there's plenty of standards to go around. The workers have to be trained properly and know their jobs. The business owners have to be trained properly and know how to keep their building safe. And finally, the employers, if different from the business owner, also has some responsibilities. We're going to walk through what the law requires for each of these people. So for employers, they are supposed to develop a plan. a written comprehensive plan that they train their employees on as far as workplace safety. Again, I mentioned to you that falls are the leading cause of injury and death on construction sites, and because of that, they pay special attention to that, and that's in bullet point 2 there. If there are skylights or any kind of opening in a roof, they're supposed to have 3 things. They're supposed to have covers or screens, railings or guardrails, and then the PFASs, the personal fall arrest systems that would protect each worker. It says they're also supposed to assign a competent person to inspect the work site before work is done to identify fall hazards and determine the appropriate fall prevention system that workers are to use. All right, now that competent person is a term of art. That is an OSHA-defined term that means 2 things. It means there's a boss on the job that is aware of the hazards. It can't just be you know, a boss's son who does the books for the company and also is in charge of safety. We're talking about a certified safety professional is a competent person, but he also, part 2 of that, he's got to have the authority to make the changes. And so in other words, he doesn't have to run to the boss man every time something messes up. He has the wherewithal in his duties and has the responsibility and the authority to make changes if they're needed to be changed. Every job site is supposed to have a competent person. That's become a standard question that I ask in depositions. You should see the blank looks that come over the faces of businesses. Never heard of it. Never heard of it. Now again, there are bulletins, there are safety bulletins that go out, but it's up to the business owner to make himself knowledgeable, him or herself knowledgeable of these kind of rules and regulations if they're going to be making money putting people in danger. Employers are also supposed to periodically inspect both scheduled and unscheduled inspections so that the worker always doesn't know when it's coming. They're supposed to, of course, provide training to any worker who could potentially be at risk for a fall hazard. So that's kind of in a nutshell. There are more rules, but that's in a nutshell what employers are supposed to do. Now, business owners, say for instance in the first case we talked about, the business owner where the work was happening was different than the employer of my man cleaning the gutters. He was hired by a subcontractor, sent out to an industrial site, so both his employer and the business owner where the skylights were have responsibilities. Building owners are supposed to provide workers with printed documents showing the exact location of each and every skylight on the roof where they'll be working. That seems like a fair thing to do, right? If you're going to be up on a roof 30 feet, I sure would want to know if there are fall hazards. They're supposed to install anchorage points. It's ways to fix these fall arrest systems onto the roof, whether it's a hook or, you know, it's got to be sturdy enough to hold a falling worker. And again, you can't just trust your local carpenter to know how to properly install these. You've got to make sure that if you are a business and you put one up, OSHA will be glad to come out and make sure you've done it correctly. And they're supposed to be clearly marked, those anchorage points, so they know when they get on the roof where they need to go to tie themselves off. They're supposed to install those permanent railings that we talked about, or protective screens if they can't do workers. If they can't do railings, they can do protective screens instead. Significantly, building owners are also supposed to post warnings like this one that says, danger, do not step, stand, or sit on skylights, injury or death may result. It was undisputed in any of the 2 cases we've talked about so far that there were no warnings at all. It would be a tougher case for the plaintiff had there been warnings posted, had they given them a safety sheet when they pulled up in the parking lot, or had they even had a sign like this posted on the side of the building or on top of the building, warning people that there are skylights, because again, they're hard to see, especially if they're the flat corrugated kind that line up, they look like the same building. They're supposed to post the signs at all entry points, doors, stairs, ladders, or roof hatches, and they're also supposed to lock any doors to limit the roof access. You know, a lot of times you'll see ladders going up industrial buildings. Some of them are locked. All of them should be locked. Only some of them are locked. All right, so I'm going to introduce you to a business owner here. He will remain nameless. But this is this case in Clark County that I was telling you about earlier where the worker was paralyzed. This was a business owner in that building. Do you know if OSHA standards require you as a commercial business owner to equip skylights with a skylight screen?
I do not know that, no.
Do you know if those OSHA standards require you as a business owner to cover skylights with any kind of railing all the way around the skylight?
No.
Knowing that they aged and had mildew, did you take any steps to make sure that they were still safe?
I thought they were safe.
Had you taken any steps to find out if there was anything you needed to do to keep them in compliance with any kind of standards?
No.
Are there any warnings on the roof, warning people on the roof that there are skylights?
I never had anybody on the roof to warn.
Are there any warnings on the roof warning people that there are skylights?
There's not a warning on the roof in Thomasville that I know of.
I'm asking about your building.
No.
Are there any warnings on the side of the building warning people that there are skylights on the top of the building?
No.
Are there any warnings on the front of the building?
No.
Are there any warnings of any kind letting people know there are skylights? Okay, so undisputed in this case. Sometimes you would have an argument over some of those facts. That made this one a little easier, although they still argued to the end of the case almost that the worker was responsible for his own injuries, and you'll see that clip in just a minute. Well, if the employers and the business owners do what they're supposed to do what they were supposed to do, then the workers also are charged under OSHA with some very specific and very detailed obligations. They are, of course, if they know about them, are supposed to never to stand, sit, or lean against any kind of skylight. Significantly back to the first case, the one where I showed you the comparison between the two skylights, the deteriorated one versus the new one. We had an expert testify and do some testing in the case with some other skylights. Do you know that it wouldn't even have held a tool bag if it was just, not even dropped, if it was just sat on there, a 30-pound tool bag straight to the floor? Some of them were rain. We were out there on a rainy day and rain is just pouring through these skylights. Extremely dangerous, and again, that building, when I checked last week, still has those old skylights. It's a scary, scary thing. Workers are also supposed to guard any holes that they have to uncover during the course of their workday. Of course, they're free to ask their supervisor to help them out with any kind of procedures. And if they don't know about fall protection systems, then it's up to the worker to learn about them. So it's not all blamed on the businesses anymore, and that's the way it ought to be. You know, if a worker is going to get paid, he ought to know how to do his job, right? And so workers have some responsibilities too. They're supposed to always use those fall arrest systems when working at a greater than a 6 feet height above a hole. You're supposed to daily inspect those, and again, we've handled some cases against those fall arrest systems that don't always work right, and one of the first things they want to see, the manufacturer, is show me how you inspected it and show me proof that you inspected it, because they'll put check sheets in there where they're daily, kind of like you might go in a restaurant bathroom and there's a check sheet of who cleans the bathroom last. That's the kind of procedure that they want workers to put in place so they know when these things have been used correctly. All right? So again, keeping in mind this photograph has 4 or 5 other skylights besides the only one that I dare say anybody in here can really see. So keeping in mind the fact that we have a 52-year-old man who's permanently paralyzed, the worker, the owner earlier you heard say no warnings, no signs, no kind of steps in place to rehabilitate any of these skylights. I asked this owner what responsibilities he thinks his company has for this paralyzed man that's left in Clark County, which if we had not recovered for this worker would be, it'd be up to the taxpayers to support. And so that, you know, a lot of times we forget that part of it, but we think, you know, there's a lot of talk about conservatism in Alabama. Well, conservatism means taking care of your workers. It means that if you don't take care of them, they're going to be on the government dole. Now, to me, that's a conservative principle that business owners ought ought to be to take their own responsibility for. So I showed him this picture again, and I asked him some questions about whose responsibility it is.
What color is the mildew on these skylights?
It's gray.
And what color is the metal roof?
It's gray.
The skylight that Mr. Cowan fell through, did it also have mildew on it?
It's basically the same as that one.
If you had knowledge that a skylight was brittle and would not support any weight or any appreciable weight, do you believe that you would have any obligation to fix it?
No,
Do you believe either you or your company or the owner of this building has any responsibility at all for what happened?
I do not.
Not even in the least?
No,
You don't believe you made any mistakes in the keeping the upkeep of your building or anything?
that's right. And when I go to bed at night, I can sleep.
All right, pretty strong testimony. Unfortunately, a jury never got to hear that part. It was settled at mediation just before trial. But that, I think, is a good indication of what some of our workers have to deal with in our state. Of course, not all business owners are like that. Wouldn't paint everybody with the same broad brush, but there are any number of workers who every day when they climb a ladder or get in the back of a work truck are putting their lives on the line because the people who are paying their paychecks are not providing them with the right kind of safety equipment. All right, now certainly industrial accidents can happen from above, skylights, ladders, and things like that. I want to talk to you right now about another case that happened way below the earth. This is a shuttle car. Shuttle cars are designed to carry thousands of pounds of coal from where they dig coal off the seam, off the rib. They'll put it in these and they'll send it to a conveyor belt and it's taken out of the earth. This particular, this is not the exact machine, and I blanked out the manufacturer of this machine. But this is an example of a case that Bob Prince and I just settled earlier this year, actually late December of last year, where a worker was driving one of these shuttle cars and it malfunctioned on him. These shuttle cars like this, believe it or not, do not have seat belts. They're not required to have seat belts. MSHA is the companion governmental agency to OSHA for below ground. It stands for Mine Safety and Health Administration. They do not require seat belts in machines like this. They're optional. We don't believe that's a good idea, and I'll show you why in just a minute, because these machines, while they don't go very fast, the conditions, I'm just curious, anybody ever been underground at a mine? All right, so this happened at Shoal Creek Mine in Jefferson County. When we went for the inspections, went a mile deep and 3 miles in, right? So you're way under there. and you know, if I don't ever have to go back, I'll be okay. But my hats off are to the mine workers of America who do this kind of dirty and dangerous work every day. Unfortunately, my client, and it may be a little hard to see in that photograph or not, but that is a piece of coal sitting on top of my client inside his shuttle car. Can we get the lights? Yeah, just those so they can see it a little bit better. This was taken while he was still in the car before they were able to hoist that rock off of him. The rock itself weighed 2.5 tons. Had pinned him into the compartment there. Let's leave them off for just a second because I have an animation I want to show you next that our expert witnesses put together to talk about this case. I want you to pay careful attention as you're looking at it. We'll play it a couple of times because it'll give you a good idea about how rough these roadways are. It's not like driving down the interstate. I mean, these are heavy, heavy pieces of equipment. They make heavy ruts in the roadway. And when they do, it bounces the workers all around because they're not required to wear seat belts. Seems pretty straightforward to me. So this is the animation of what this worker faced. Shuttle car's coming toward us. You see a big dip and drop, and then he loses control because the first time he bounced, he broke his neck. The doctor said it threw him into the cab. You'll see him, it knocks off his hard hat, and the rock comes in and pins him where he was pinned for a couple of hours before they were able to hoist that off of him. I'm going to show it one more time now that you know what you're looking at. You can see the shuttle car bounced violently, and because, again, he's not belted, and because there's not a whole lot of clearance to where his the canopy top of the equipment is, it broke his neck on initial impact, and he was not able to hold on to control the shuttle car anymore. Experts testified in this case that had he had a seat belt, that he would have been able to maintain control of his car, and this would not have happened. Let's see, that's again another picture of the shuttle of the rock on him. That is his seat that the rock is sitting in. He is down in the floorboard under that rock. We'll talk about his injuries in just a minute, but he was lucky to survive. All right, so like I mentioned, he broke his neck by bouncing into the canopy. It prevented him. It's a complicated job. You've got to use your feet and your hands to steer those things. And when he lost his, when his neck was broken, he was not able to control. There's also a NIOSH standard for these kind of cars. That's the National Institute for Occupational Safety and Health, which says for seating design principles that there should be an active occupant restraint system, a seat belt, should be incorporated into the seat or workstation to prevent the operator from being thrown out of the seat during any turn, bump, or collision. Again, exactly what we're doing. I mean, that's why they recommend these things, because of exactly the kind of injury that my client suffered. Now, interestingly, that last bullet point we were able to really use in this case. I wish I could show you the documents. They're subject to a confidentiality order in this case, but the documents, they do these design risk assessments or analyses where at the beginning of the manufacture of these very expensive shuttle cars, they will say, the engineers are much, much smarter than I'll ever be, and they plan for everything. They say, well, what if this happens? What if that happens? Well, there were several times in those documents where the engineers suggested that seat belts be mandatory. The company rejected each one of those. And interestingly, I didn't write the word rejected, they did. It was all through the company documents. Blank manufacturer rejects seat belts here, rejects it there. And again, mostly it was a financial decision. And that's kind of hard to stomach, and it's hard for a jury to stomach that if you wouldn't spend $30 on a seat belt to save a worker 32 days on a ventilator, which is what happened in this case. Our expert witness testified very well in this case that there not only is there an alternative, but it's an economical alternative. A seatbelt does not cost that much money when you're talking about one of these multi-million-dollar machines. Those are just the dimensions of the seat. But that's an important part of any kind of product liability case. Alan can tell you he handles them too. It's not just enough for we as lawyers to say that the product was unsafe and it should have done something different. We have the burden of proof to show, well, that's true, but also there's a cheap and safe alternative design. And a seat belt is what would have made all the difference in this case. Just a kind of a thumbnail sketch of my client's injuries. 32 days on a ventilator. He had bilateral clavicle fractures, which an orthopedic surgeon said in his deposition, nobody survives that. That's just an indication of how much force you're crushed with to have both of them broken. A torn aorta that almost never healed, never able to work again. All he ever knew was underground mining, and he's never been able to work again. Medical expenses of $581,000, future lost wages, and so we calculated his total damages being right at $1.6 million. Again, which, even if he was able to go back to work, there's no way that a worker with that kind of education could ever have recouped that. All right, so we've talked some high injuries, we've talked some low injuries. Let's talk kind of one in between here. Ladders are things that are prevalent on industrial and construction sites, and they can be very dangerous too. This case happened in Wilcox County, and we just resolved this one last month at a mediation. We represented the truck driver who was required by a company that he was delivering to and from to use this particular ladder to climb in and out of his 18-wheeler. Now, he's been driving trucks for 30 years, and this is the only location where he's ever been required to use a ladder. You know, there are steps on the trucks themselves. There are handles on the side of the truck that you don't even need a ladder. This particular company is called a spotting company, and what that means is they work at a yard, say a pulp mill or a paper mill, and they kind of help the company move trucks around the yard. Their job is to spot, to marshal the trucks around the yard. And this particular company made him use this ladder. It was not designed for this purpose. That orange handle there is kind of hard to see, but over to the far right in front of that dumpster did not come standard on this ladder. They kind of installed that after the fact. Interestingly, they picked a ladder with wheels on it. All right? And so this kind of ladder is fine when you're walking up because the way it's designed, as you put pressure on the bottom steps, it kind of locks the wheels in. They don't go anywhere. That's fine going up. It's not so good coming down. And sure enough, when this worker this time came down the ladder, he fell, hit his head, broke his wrist, and was never able to drive a truck again. Again, he went to work one day trying to do his job. They made him use a ladder, and this is what happened. There wasn't a good picture that would do it justice, but not only did this company make him use a ladder with a handle that didn't belong and a ladder that wasn't intended for this purpose and a ladder with wheels on it, they also made him park on a hill. And so he parked on a decline, or actually on an incline, but the back of his truck was going down the hill, and sure enough, when he came out, he busted it and was injured pretty badly. There are also cases involving bridges out there. A lot of bridge work, a lot of road work in our state, obviously. This is a bridge site that is on Highway 82 in between Tuscaloosa and Gordo, if you've been that way, on the way to Mississippi. This is called the Sipsey River Project. And we represented a lady who worked for ALDOT. She worked for the Department of Transportation. Her job was a bridge inspector. She was supposed to get out there and make sure they were doing it the right way, and you can't do that job from your truck. You got to get out on the site and do it. And so what happens when they build these bridges is obviously there's all kind of elevation changes, all kind of different kind of soils that they have to deal with. You see the things with orange paint in the background? Everybody see those sticking out of the ground? Those are called pilings. They're steel I-beams, and they're 1,000 pounds per square foot. They're heavy. They got to be to hold traffic over the course of 50 or 100 years on the roadway. And what happens, they take a big crane with a hammer on the end of it, they get it in the right place, and they pound it down, and then eventually they've got to cut them off. They've got to make them all the same length. Well, in this case, my client, much like one of these workers, is down there making sure they're doing it correctly, and they are driving the pilings and then cutting them, and they've got a procedure in place where this bridge company was supposed to tie off the top of the pilings before they cut it with a blowtorch, and then they push it over and they kind of gently let it to the ground. All right? They're in a hurry. They're trying to meet their time commitments, and let's say, we don't really have to tie these off. They're only, 6 or 8 feet. Well, keep in mind 6 or 8 feet, that's 6,000 or 8,000 pounds of steel. And so they push it off. It's kind of like when you're cutting a tree maybe and it doesn't go all the way through. There's a part of it on the back and it twists and it comes right toward her. So she's able to get out of the way. It hit within a foot of her, but she fell and broke her arm as a result of that and was never able to work again as a DOT inspector, all because this company kind of cutting some corners on a safety aspect on an industrial site. As it turns out, OSHA has a standard in place for this. This particular company had never heard of that either, but when it says when it is necessary to cut off the tops of these driven piles, all kind of pile driving operations are to be suspended so long as the worker is any closer than twice the length of the piling. So if you're going to cut off a 4-foot piece of piling, the worker's got to be at least 8 feet away. Now, if it was me and 4,000 pounds of steel's falling down, I want to be further than 8 feet away, but you get the point. They got to be at least twice the distance of the pile away before they're supposed to fall. And so I want to save time for some questions. But, you know, it's impossible to cover all the industrial accidents that might occur. We're currently investigating cases involving man lift baskets. I'm working a case right now that happened in Shelby County where a worker was hired to sandblast one of those big water tanks. You can see them right from the interstate on 65 in Pelham. And the man lift basket that he was using malfunctioned and he fell 50 feet. Survived, but listen to this, on his way down, the sandblaster that he's using won't cut off, and so it's into his arm and digs a hole. I mean, it's terrible, and so he's not able to work again either. We also work cases involving cranes. Playground equipment can be very dangerous. You don't think about that kind of thing, but if you've got kids or grandkids playing on playground equipment, I would want to be careful. Because not all of it is put together correctly, and there's got to be certain kind of flooring underneath. One case I'm working on right now, it involves a fireman's pole at a playground, and instead of wood chips or rubber pellets underneath, because kids are going to fall on playgrounds, right? I mean, that's what happens. Instead, they have concrete at the bottom of one of these fire poles. You can imagine what happened when that young boy hit the concrete. So. It's been a pleasure being with you here tonight. I do want to save time for questions, and I've got a few more things I can cover if there aren't any questions. Or you're asking about liability of a homeowner concerning skylights. It would be much like a business owner. It'd be a little bit harder to hold a homeowner liable, but it's one of those things that if you know of a defect in your home and you don't warn your guest of it and they get injured, you can be responsible. Does the homeowner have to have all these signs? There's no requirement, but again, if it was me and I had skylights in my house, I'd want some signs up there. And it may just be because of what I do for a living, but you know, I've seen some bad things. But okay, a worker coming to work on the home. Okay, yeah. So yes, in that case, if there are skylights that are hard to detect because of mildew, because of the same coloring issues, and a worker gets hurt, I do believe you could be held responsible for that. Yes, ma'am.
What is the role of workers' compensation in these cases?
The question was, what is the role of workers' compensation in the cases? Both of those skylight cases, the employers did not have workers' compensation coverage. You know, it's not required in Alabama unless you have so many employees. Some companies, even if they have the right number of employees, don't pay for the insurance. And so, again, in that case, that's what I was talking about. If there's not workers' compensation coverage, Medicaid or some government benefit has to pick it up. Yes, sir.
Are these examples related, are OSHA rules related to industrial type facilities, or do they spin off down to commercial?
There are standards that apply solely to the construction industry, and there are some that apply a little more broadly than that. The test is what kind of activity is the worker performing. If it's maintenance type things, then there's going to be an argument in the case as to whether OSHA applies. If it's construction, then it definitely applies.
And then you hit on another one with the number of workers by the business. Some small, if you're less than 50 or less than 15, certain
Right.
things don't apply to you.
Right.
Is that true with these also? If you're like a one-person job shop, or?
Again, it depends on the kind of activity more than the number of people. But and we do represent some businesses, and we've been hot to trot making sure that these companies are at least provided with this material, because well-meaning business owners have never heard of these things. You know, and if I owned a business where workers were working around skylights, I'd want to know the rules for sure to cover myself. Yes, ma'am.
If a waitress, you know, they make $2.13 an hour. I'm not kidding.
Right.
If a waitress gets hurt on the job in a restaurant, is she eligible for workers' compensation?
The question was, a waitress working for $2.13 an hour is hurt on the job, is that waitress covered by workers' comp? I hope so. If there are enough employees and if the employer does what he's supposed to and has workers' comp coverage and you're injured on the job. And again, that's the beauty about workers' comp. You know, there are all kind of bad parts about workers' comp, but there are some good parts too. It doesn't matter why you're injured on the job. If you are injured on the job and they have workers' compensation insurance, they're supposed to pay for your medical bills.
Do you happen to know the number of employees that are
Alan, do you know the number? Is it 3? All right, our expert in the back says if you have 3. Yes, sir.
Mr. Hayes, regarding damages, most of these, or a good number of these cases are settled out of court and
Right.
mediation and stuff, probably because of the fear of the punitive damages. Would you agree with that? And then the other thing I want to ask, you tabulate something for the compensatory damages. Would you say it's, what kind of percentage is, gained from a suit? Is it normally around 100% of the compensatory damages?
All right. So it's a long question. I'm going to do my best to repeat it. No, it's okay. It's fine. It's a good question. So let me take the last part first. So on the slide where I calculated the damages, he wants to know, that seemed to be mostly compensatory, and you're right. He wants to know, is there any kind of percentage that correlates if you're able to hit the business for punitive damages? Is that?
No, sir.
No, okay.
Most of these people that are can't work again, are you hitting 100% of the compensatory
Oh.
damage?
Are we able to recover 100% of the compensatory damages in a typical case? Fortunately, we have been able to do that. Every case is different. It depends on where it happened. It depends on how likable the plaintiff is, how bad the conduct of the defendants are. But cases can have problems, and so I can envision some cases where you calculate X number of damages, but say the worker did not have very clean hands in the deal himself, he might not get all of it. He might have to get a discount to get anything.
So even though Alabama doesn't have the percentage of fault,
Right.
it still kind of acts out in the damages.
The question was, even though Alabama does not have a comparative fault percentage kind of deal, it still plays out. It would play out both in a jury context where a jury might weigh some of those factors, but certainly for settlement value, if lawyers are talking, no lawyer, even as good a one as Alan, who's been doing it for 100 years, can predict 100% of the time what a jury will do. All we can do is our best judgment based on prior cases, and so it's a risk-reward kind of analysis, and you might have to take less if you've got problems with your case. Yes, sir.
If you get a judgment, but the business isn't worth the judgment, what happens?
If you get a judgment, but the business is not worth what the judgment is, what happens? Well, in that case, you hope that they have insurance. Absent that, you can record a judgment, and it's good for 20 years, and you hope that business wins the lottery, and you kind of track them around and garnish their wages and try to seize bank accounts. But that is a very real concern in these cases, because a lot of these companies are fly-by-night kind of companies with no insurance. And if they don't have any assets, then a lot of times you have what lawyers call a paper judgment, not worth very much.
Can they just declare bankruptcy and
They can declare bankrupt.
under another name the next week?
They can, and that's a scary proposition to cases. Yes, sir.
How long, if you are hurt on the job, not obviously like your examples, how long can you go before you want to look into a lawsuit?
Okay. If you're hurt on the job, how long can you go before you want to look into a lawsuit? Well, the first thing you got to do if you're hurt on a job, and this is very, very important, is you must report it to your supervisor. It has to be documented on what's called a first report of injury. It's a government form. It's got to be documented. And from that time, you have 2 years from the date of the injury or 2 years from the date of the last workers' compensation payment to file a lawsuit. Yes, sir.
Do you and your company only represent the injured worker, or do you sometimes find yourself representing the owner of the business or the owner of the construction company?
The question was, do we ever represent the businesses or the company owners or only the injured workers? My practice primarily is representing injured people. Now, we have on occasion over the years represented businesses, more like a consulting kind of role. We've seen some of your work in your cases, what could we do to protect ourselves from you coming after us later kind of deal. But, if you're injured, if somebody is injured on your job site, hopefully you have insurance. That insurance company is going to hire a lawyer. you're really not going to get to choose your own.
What
Yes,
is the
ma'am.
statute of limitations for injuries on the job?
The statute of limitations for injuries on the job is 2 years, but again, you must report it to your employee as soon as possible, usually the first day.
So the guy that was underneath the 2.5-ton rock needed to file a report?
Well, that's a good question. So the guy underneath the 2.5-ton rock needed to file a report. Technically, he did. Now, you don't have to do it personally, and thankfully his foreman did that for him. Yes.
Thank you. Good to see you.
Enjoyed being with you. Thank you.
Thank you.